Thank you, Mr. President. I thank my colleague from Kentucky for giving me the opportunity to ask a question. And in the preface to that question, I'd like to make a couple of remarks, if he will yield to me for that purpose. My colleague from Kentucky, I think, has taken the floor tonight in the highest traditions of the United States Senate to make a point that should be meaningful to all of us who care about our democracy. My colleagues, including the senator from Kentucky, have made a number of important points about the danger of mass surveillance and the harms caused by bulk collection of American data. And I agree with those who have pointed out that the USA Freedom Act is a strong compromise solution for protecting American freedom and security, at the same time striking a balance between preserving our security and protecting our precious rights. And I want to highlight for the senator from Kentucky, in his very insightful remarks, as well as for my colleagues and others who are interested in this topic, a particular part of that legislation, provisions that deal with the adversarial process in the FISA court. The bulk collection program is a powerful example of why we need a stronger adversarial process. We know that bulk metadata collection is unnecessary. The President's own review group has made that clear. We also know that bulk metadata collection is un-American. This country was founded by people who rightly abhorred the general warrant, and no general warrant in our history has swept up as much information about innocent Americans as the orders permitting and enabling bulk collection. Last week, the Second Circuit Court of Appeals held that bulk collection is also unauthorized by the law. More than 9 years after the government began bulk collection, we are finally told by the highest court to consider the question that the bulk collection program was never authorized by Congress. How did we get here? How did we arrive at a place where one of the most respected courts of appeals in the United States says that the executive branch of our government has been collecting data on innocent Americans without legal authority to do so, in fact, breaking the law by invading Americans' privacy? We got here because the FISA court failed its most crucial test. In May of 2006, the FISA court was asked whether the federal government could collect phone records of potentially every single American. The argument hinged on the word relevance, quote, relevance in the statute. Under the statute, the federal government can collect relevant information. The court had to decide whether relevant information means all information. That doesn't strike me as a difficult question. Does relevant information mean all information? And it didn't strike the Second Circuit Court of Appeals as a difficult question either. The Second Circuit held that the federal government's interpretation is, quote, unprecedented and unwarranted. Strong words for a court normally extraordinarily reserved and understated in its characterization of illegality by the executive branch. But the court said it unequivocally and emphatically: the government was breaking the law. Never before in the history of the nation had such a bizarre interpretation even been entertained. At the very least, you would have thought that the FISA court would recognize that its May 2006 decision was important. If this question had gone to a regular Article III court, it would have been immediately recognized as a momentous decision permitting bulk collection of data on every American. Litigants on both sides would have, in effect, pulled out all the stops in their arguments. Yet, not only did the FISA court get the question wrong, in May 2006, it appeared not even to have spotted the issue, not even have raised it and addressed it in its opinion. Of course, nobody knew it at the time because the opinion itself was kept secret, as were all of the proceedings on this issue. The FISA court upheld the government's bulk collection program, and it did so without even writing an opinion explaining its legal reasoning. Not until the program was made public, roughly 8 years later, was an opinion written, and every opinion released so far has omitted key issues or ignored key precedent. If the court had written an opinion, at least Congress would have quickly known what the court had done, not to mention the American people knowing what the court had done. But the court wrote nothing. It chose to be silent and secret. And apparently it believed that this issue merited no notice to the United States Congress. A court that could get such an important question so disastrously and desperately wrong is fundamentally broken. Now, let me be clear. I don't mean to denigrate the judges of the FISA court. Any judge, no matter how wise and well attuned to legal issues, needs to hear both sides of an argument in order to avoid mistakes. Courts make better decisions when they hear both sides. In fact, during a hearing on this issue in the Senate Judiciary Committee, I had the opportunity to ask one of the nation's foremost jurists whether she could do her job without hearing from both sides of an argument, and she was quite clear, no, she could not. Adversarial briefing, she explained, is essential to good decision-making. We know as much from our own everyday lives. We make better decisions when we know the argument against what we're going to do, what we're going to think, what we're going to say. It's the genius of the American system of jurisprudence that judges listen to both sides in open court before they make a decision, and their rulings are public, they are evaluated and judged themselves. 9 years after the FISA court's ruling in May of 2006, we continue to wrestle with the impact of the court's grievous, egregious error. But we cannot simply fix the mistake without fixing the court. We can't fix the system without remedying the process. Because that process is so broken, it will make more mistakes, not only predictable, but inevitable. As technology evolves, we cannot say with certainty what the next big privacy issue will be. In 2006, the FISA court decided whether government can collect all of our phone records. In 2020, the government will have some new means of surveillance, and they'll want to try it. In 2030, we'll have another. We need a FISA court that we can trust to get the question right. Trust is at issue here. Confidence in the integrity of the judicial system that authorizes surveillance of Americans' private lives. We need a FISA court that operates transparently, openly, accountability, a court that operates in secret, hears only the views of the government, and faces only minimal appellate review, and therefore cannot be trusted to pass the next big test. The USA Freedom Act would fix this systematic problem. It would demand, under certain circumstances, that the FISA court hear from both sides of the issue and explain why it is making a decision, and also explain why it has decided not to hear both sides if it chooses to do so. It would bring transparency to the FISA court decision, requiring them to be released unless there's good reason, not to release them. It preserves the confidentiality of the court where necessary, but it also protects the fundamental, deeply rooted sense of American justice that an adversarial, open process is important, indeed essential to democracy. And it would provide some appellate review, some form of review by an appellate court so that if mistakes are made, they are more likely to be caught and stopped before they result in fundamental invasion of private rights. In short, the USA Freedom Act will make the FISA court look more like the courts that Americans deal with in other walks of life, more like the courts that they know when they're litigants, when they're spectators, more like the courts that our founders anticipated. What would they have thought about a court that hears cases in secret, makes secret decisions, operates in secret, issues secret rulings that get it wrong? They would have thought, that sounds a lot like the Star Chamber. That sounds a lot like the so-called courts that caused our rebellion. This change will help ensure that we are not back in this chamber 9 years from now debating the next mass surveillance program that started without Congress actually authorizing it, as did metadata collection. It will help ensure that strictures of our Constitution are obeyed in spirit and letter, and it will help ensure that programs designed to keep Americans safe can command the respect and trust they need to be effective. We need those programs. National security must be preserved and protected, but we need not sacrifice fundamental rights in the process. Unless and until this essential reform is enacted, along with the other essential reforms contained in the USA Freedom Act, I will oppose any reauthorization of Section 215. So the question that I asked my colleague from Kentucky, and the point that I think he has made so powerfully and eloquently, relates to this essential feature of our American jurisprudence system. Are not open adversarial courts essential to the trust and confidence of the American people? And do we not need that kind of fundamental reform in order to preserve our basic liberties? I asked this question of my colleague and friend from Kentucky because I think that his debate on the floor of this Senate tonight raises fundamental issues that need to be discussed and addressed. And I thank him for the opportunity to ask this question and address this body. Thank you, Mr. President.